free to raise your hand metaphorically. There's the option on your screen, and we'll try to get to all the questions. We're going to be covering today the Fifth Circuit decision, as well as what has happened, a little bit of background as to what has happened in the lawsuit, what's going to happen next, and then give an overview of the bigger political context and what we can do moving forward. A little change in programming. Unfortunately, our Director of Regional Advocacy, Jackie Vimo, can no longer join us. So Christina, Betsy, and I will be taking on those topics as well. And there will be an opportunity at the end for folks to ask questions. So as a brief refresher, Texas versus the United States. And actually, before I get started, I want to give a big thank you to our friends at the National Immigration Law Center, NYIC, who provided a lot of the information that is contained on these slides. So a big thank you to them. So in late 2014, just a few short weeks after the November 20th announcement by President Obama that he was going to be taking executive action to provide administrative relief to immigrant communities in the face of inaction by Congress, a few weeks after that announcement, the 1 year anniversary of which is this coming Friday, 26 states led by the Attorney General of Texas, 26 states filed a lawsuit in a federal district court in Brownsville, Texas, seeking to enjoin the president from expanding on his DACA, on his original DACA program from 2012, and also seeking to enjoin the newly created program, Deferred Action for Parents of American Citizens and Green Card Holders. And what that means is that they were looking to stop these programs from being implemented and providing the much needed relief to our immigrant communities. In the course of that litigation on February 16th, 2015, the federal district court judge in Brownsville, Texas, Judge Andrew Hannon, issued what's called a temporary injunction blocking the expansion of DACA and the newly created DAPA programs from going forward. A temporary injunction means that until the judge put a pause on the programs until he had an opportunity to review the entire merits of the case and make a decision on the arguments put forth by Texas and the 25 other states that the president had exceeded his authority in creating formal deferred action programs for those two categories of individual. So the temporary injunction went into place on February 16th of this year, just 1 day before the expanded DACA program was going to begin. The government, the White House, immediately asked for a stay of that injunction, meaning that they were going to appeal the decision, and while the decision was pending, they asked for the judge not to enforce his own decision. The judge denied that fairly quickly, and so a motion for a stay was filed in addition to an appeal to the Fifth Circuit Court of Appeals, which has jurisdiction over the Texas District Court. So they, in non-legal terms, what that means was that they asked for both the Fifth Circuit to reverse the judge's decision granting a temporary decision. They asked the Fifth Circuit to agree that with them that the judge did not, that the states did not meet the requirements to justify having a temporary injunction in place. But they also asked the Fifth Circuit while the Fifth Circuit was making their decision, to not enforce the judge's order so that the programs could at least begin. On May 26, 2015, a panel just on the motion for the stay decided against the government and denied the request for the stay, meaning that the injunction held while the appeal was pending. And then on July 10th, 2015, they heard oral arguments on the appeal itself. Now, it's important to remember that the appeal is only of the temporary injunction, meaning that the case that the states filed against the government alleging that the president oversteps his authority, that is still going on, and that hasn't been decided on. That question has yet to be resolved. what we are fighting for now is this temporary stop on the programs while that question is decided. We're fighting for that to be removed so that while the case makes its way through the court, right now it's still in Texas, still in front of the district judge, so that we can continue with the programs while the litigation gets going. So then what happened last week on Tuesday, November 10th, that appeal was dismissed. We were expecting that ruling. There have been at this point 4 judges in the Fifth Circuit that have touched on this case. The 3 judges or justices rather that were part of the motions panel that denied the stay request, and then 2 of those judges, both appointed by Republican presidents, were also on the panel that on the 3-justice panel that decided the appeal. But a different judge made up the 3rd part of that panel, meaning that 2 of the judges, both appointed by Republican presidents, were on both panels, and only the judge with the opposing opinion in both times were different. So the result was expected. The Fifth Circuit is a very conservative court, especially when it comes to immigration issues, and the judges had already made known in their first motion panel decision where they stood on the issue. So it really wasn't a surprise. The basis for the decision was that the judges found that Texas at least was making a valid claim that they might be incurring costs because of the costs that would be associated with granting driver's licenses to immigrants who might be able to obtain work authorization under the programs, under the expanded DACA and DAPA programs, meaning that Texas had at least shown that they were going to suffer some sort of consequence of the president's decision, and therefore they had a right to sue in federal court if they felt that that was harmful to them. They also found that the Fifth Circuit agreed with the court in Texas that that the states were likely to succeed, that DAPA should have been subject to notice and comment under the Administrative Procedures Act, meaning that the president could not just unilaterally make the decision to grant DAPA to individuals and create an application process, but rather that he had to put a proposal together and leave it open for a certain period of time for comments by the general public as required for certain programs under the Administrative Procedures Act. This court also went further and found that that actually under federal law, Texas was likely to win when they challenged the legality of the DAPA and the DACA programs entirely. This is not what the original denial for a stay had found, but in this opinion, they found that it is most likely that the court will end up finding that those programs are not permissible under law. And they also finally made a decision that the nationwide scope of the preliminary injunction was appropriate, meaning that the government had asked for it to be limited to only the 26 states that were filing suit, and the court found that actually it was appropriate to have that injunction applied to the entire country. So those are the basic premises on which this decision from last week was based. And what this really does for us now is that it clears the way for an appeal to the Supreme Court. So to discuss a little bit about what the decision means and then what the path forward looks like, I'm going to turn this over to my colleague, Christina Chang.
Thanks, Camille. So I am going to give an overview of the timeline that we're working with to ensure that the Supreme Court does indeed actually hear this case. We are still waiting on the Solicitor General to file cert petition, and that's when the clock basically starts for the Supreme Court to request all the materials and then make a decision on whether to put it on their calendar. We have been very clear with the Solicitor General, our national partners have, that we want them to file the cert as soon as possible. We are still hoping that they will do so this week. And once they do, they typically have 30 days to file amicus briefs in support of their position. Due to the timeliness of the issue, we imagine that the period for an amicus brief to be filed will be shortened to maybe about 15 days. And then after the amicus briefs in support of the federal government are filed, then the states have their chance to file their briefs and their amicus briefs as well. We are imagining after all these documents are submitted, the Supreme Court will sometime in January or February conference to decide what will be on the calendar for 2016. And so that is when we imagine there will be need for folks to mobilize to DC and sway the public narrative in favor of the Supreme Court taking this momentous case in 2016. Theoretically, if they decide to take the case, if they decide to hear the case, it could happen as soon as the spring of 2016, and a decision could happen as soon as June. Now, this is the rosy-colored version of what could happen. We may be looking at a decision coming sometime near the November elections, and so as you can imagine, that's going to be very problematic for any implementation. So I think now I'm going to turn it over to my colleague Betsy here to kind of talk about the larger political context. Betsy.
Thank you, Christina. So I'm going to go a little off script here to sort of talk when we think about the marriage equality case, which you can see this great, powerful picture here, and when we think about other big cases that have come in front of the Supreme Court in the last couple of years, of course, we have the marriage equality case as well as the Affordable Care Act case. We've really seen in the news, and we did have arguably from our side of things favorable decisions in those cases, that what the Supreme Court decides can cause significant ripple effects and influence law, policy, and lives beyond those that are just in the immediate case. And that's why these decisions were so powerful, impactful, and really did say that the programs that they decided around and the policies that they decided around were far more solidified and protected. And that's what we want to see here with DACA, DAPA, and what the president is really allowed to do in the realm of immigration. That's why this is so important. We're deciding on something much bigger than just DACA and DAPA. And for that reason, we need to do what was done in these two very important and precedential cases. We need to put boots on the ground, and we need to make sure that the public and the court sees that this is an issue that will impact communities across the nation. And so while we know, of course, the court is meant to be impartial and unswayed by public opinion, everything about this case has been political, and the mobilization and push to the court needs to be just as political. And we need to follow suit with what's happened with other big decisions in front of the courts. And one issue that does make this even more important for the communities that we represent is that there are really big potential consequences from a negative decision on the part of the court. As one example, if the Supreme Court were to discuss the constitutionality of what the president has done, and to really discuss whether this is something that the president can do within his reach and power, it could open up new challenges to similar actions that the president has taken, of which, the greatest one would be the 2012 Deferred Action for Childhood Arrivals DACA program. And so while at present this program is completely safe and secure, and we want to encourage individuals to be applying into it, we need to understand that the stakes are high, and that if there were an unfavorable decision, a challenge could be brought to DACA. And if the court has said that the president isn't allowed to be making the types of moves that he made with DACA, expanded DACA, and DAPA, then that opens up the challenge to 2012 DACA. So another reason to actively mobilize and organize. Until then, and thank you, Christina. So what can we do now? We need to organize, we need to mobilize, and before I turn it back over to Christina, I want to say that it's a scary concept to think about DACA and the 2012 DACA program being taken away. That's very much a theoretical concept that we're putting out there as an example of why it's so important to mobilize. There are many ways that we can protect DACA. The first and biggest way is getting out, hitting the streets, and mobilizing, but it's also continuing to encourage people to apply in the program. An old mentor of mine has always said it's far harder to create a program than it's far harder to take away a program, let me not misspeak there, take away a program than create one, and the best protection for DACA is having as many people in DACA as possible. So we need to continue to encourage people to apply for DACA, but we also need to make sure that in the long term the program's protected. So with that, back to Christina.
Thank you, Betsy. So what can we do as a movement now to ensure that the Supreme Court does indeed take the case? In January and February, I've already mentioned that there will be need for some direct action and mobilization to DC. But in the more near term, on Friday, November 20th, it is the 1-year anniversary of the president making the announcement for DAPA and expanded DACA. And we'd like to not only commemorate that moment, but take that moment to bring our call to the Supreme Court to hear the case. And we will be having a press conference at 12 p.m. on the steps of City Hall to make that case. And we invite everyone on this webinar to join us and participate. Furthermore, there is an amicus brief that is being circulated by NYIC, and we will email that to everyone who is participating in this webinar to sign your organization onto the amicus brief. There will be a Google form link, and the due date for signing on is this coming Monday. And we will keep folks informed about future actions that we're going to be taking to ensure that the Supreme Court really does hear this case.
So I think with that, we're here to answer any questions. You can feel free to raise your hand by choosing that option on your screen, and we will answer the questions as they come in.
At the top of your screen, you will see a Q&A button. It looks like a folder, and you can type any questions there.
Okay, well, it looks like we aren't getting any questions. So on the last page of this webinar, we have our website and also the website adminrelief.org that's being updated by national groups to provide information, and also the New York State New Americans hotline, which you can always call, and they can, for community members who want to be connected to appropriate information and to legal service providers, you can always call that number from a New York area code. We're always available at the NYIC, so please feel free to email any one of us or to reach out to any one of us at any point. If you have any more questions or if there's any issues coming up in your community that we can help with. And thank you all for joining this webinar, and we look forward to continuing the fight and eventually being successful. Thank you.
Awesome. Okay, we have to